For motion, item 1.
May I please, Your Lordship? My counsel, my senior, the counsel for the petitioner is out of station. So if the case may be passed over for the day and listed for tomorrow.
Monday then?
Monday.
Monday?
Sir, okay.
Yes. Learned Counsel, Sri Sajan Sir submits that the leading counsel is out of station and accordingly praised for listing the matter on Monday. So list accordingly. Now put the date, okay? 3rd, yes.
For omission, item 2.
Good morning, my lord.
Yes. Pleadings are complete.
No, my lord. My lord, in this, my lord, we have, my lord, we have received, we are yet to receive the affidavit from the state.
State respondent is respondent 10. Respondent 10 is yet to file the affidavit. Okay, what about respondent 3, 7 and 9?
My lord, all our private respondents, my lord, certain service reports are still awaited.
Yes. Government? Yes.
Yes, Your Lordship. We are yet to. This case has been handled by Mrs. Carolyn. And she's on maternity leave. And Your Lordship, in this regard, we have not received any instructions or any parawise. So I have sent a reminder as well, Your Lordship. So if another 3 weeks time may be granted, Your Lordship.
I think you have been seeking time on several occasions, isn't it?
Yes, Your Lordship.
My lord,
Yes.
my lord,
Yes.
my lord, there are in total 10 respondents here.
Yes.
9 are private respondents, 10th is the state respondent, my lord. Now, my lord, out of 9, respondent number 2, 3 and 4 service report is awaited. My lord, for respondent number 1, 5, 6 and 8,
Yes.
the affidavit has already been filed. It's a common affidavit, my lord. And,
Okay, we'll give them another 2 weeks because the council who is handling the matter is on leave.
My lord.
So we will give the government 2 weeks time. 2 weeks or 3 weeks?
Your Lordship, if
3
3
weeks.
weeks may be granted.
Yes. Meanwhile, await the service on the other respondents. Okay. Learned Counsel for the petitioner, Sri Sajan Sach. Your name?
My lord, N. Khera, my lord, Nitin Khera.
Okay. N. Kira is present. Stop. The government advocate, learned government advocate, Ms. Sajan Sir, submits that the council, the government council who is handling this matter is on leave, and therefore she prays that another 3 weeks time may be given to the state respondent / respondent number 10 to file their counter affidavit. Stop. Office note dated 28/10/2025 indicates that respondent 1, 5, 6 and 8 have been represented and have already filed their affidavits. Stop. AD cards from respondent number 3, 7 and 9 have returned, but the said respondents remain unrepresented. Stop. AD cards from respondent number 2 and 4 are still awaited as on date. So accordingly list the matter of the 3 weeks. Stop. Awaiting service of notice on the respondents number 2 and 4, and to allow the respondent number 10 to file their affidavit.
Yes, my lord, I'm here for
Yes.
the respondent 1, 5, 6 and 8. And we have filed our reply affidavit.
Yes,
Just to
5,
mention.
6, 7, 8. Learned Counsel, Ms. Sajan Sach, appearing for respondent 5, 6, 7 and 8, submits that the affidavit in opposition has already been filed. You have served copy on the other side? on
Yes,
the
my lord.
My lord, we have received a copy. My lord, matter may be fixed on the 25th of November, my lord. It's a Tuesday.
list on 20, is that okay? 26?
25, my lord.
Or 25, list on 25/11, 2011. And,
My lord,
for
interim order
revision.
may continue.
And the interim order passed earlier shall continue till the next date.
Obliged, my lord.
Item 3.
Cancel.
Your
My lord, here there are two respondents, my lord. My lord, one is the private party and the second is the state. Both have been served, my lord. We have,
And respondent 2 is the state, and respondent 1?
is the private respondent, my
Oh,
lord. Private
representative.
respondent has filed the affidavit. We have received
Okay.
it. State is still awaited,
Here,
my lord.
it will be a similar order, but you just, the slight changes. You say that the order dated 28/10/2025 indicates that the state respondent number 2 is yet to file the affidavit. Stop. Learned Counsel, Mr. Lalfat Zuala appears for respondent number 1 and has submitted that he has already filed the affidavit in opposition. Stop. Here also 3 weeks.
My lord, same date, my lord.
counsel. Okay, here also, Ms. Caroline such and such is on leave and therefore list the matter after 3 weeks. Stop.
My lord,
List-
25th of
Same
November.
day. Yes,
Same day, my lord.
List on
My lord,
25th.
may I make some
Yes.
submission?
Yes.
Mahalanal Front has made sought for time to file affidavit in reply on 7/10/25.
Oh, acha.
Whether they are going to file or not. I
Yes,
think he is
petition-
silent on that.
My lord, we will be filing a reply. We are only awaiting the state's affidavit, so we file a joint reply to both, my lord, and then matter is ripe for hearing. We are only waiting for the state for
Learned
that.
Counsel for the petitioner submits that he will also be filing that he may also be allowed to file a reply to the affidavits filed by the respondents as and when the state respondents file their affidavit. Yes. So this
My
on
lord,
the same-
interim-
here also
interim
interim.
order-
Okay,
interim
same
mechanism.
interim.
Item 4.
My lord, here there are in total 11 respondents, my lord. 1 to 10 are private respondent. And my lord, 11 is the state respondent, my lord. All have been served. Affidavit of the private respondents, they have filed a common affidavit. 1 to 10 has been received, my lord. We are awaiting an affidavit from the state.
Okay. Here also similar order, but the change will be that the respondents number 1 to 10 have already filed their affidavit and is represented by Miss such and such. Stop. And then same like Miss Caroline appears for the respondent number 11. Here it will be 11/state respondents and prays for 3 weeks time. The list on 25th. Interim order. Here also interim order.
My lord, my lord.
Interim order passed earlier shall continue to the next day. Yes.
Item 5.
My lord, here there are 52 respondents, my lord. My lord, out of the 52, my lord, as per previous order, my lord, the private respondents who are being represented are 1 to 4 to 8, 11 to 22, 24 to 33, 35, 36, 41, 44 to 51. This was the earlier, my lord.
Yes, latest 2810 office note also same thing.
My lord.
And AD cards still awaited from some of them.
My lord.
Okay, so similar order and use the change will be that the respondents number 1 2 comma 4 to 8 comma 11 to 22 comma 24 to 33 comma 35 36 41 44 to 51 are represented by MS such and such and counterfiled. And the affidavit in opposition has already been filed, isn't it?
Yes, my lord.
Stop.
My lord.
The AD cards in respect of respondent number 1, 3, 9, 10, 23, 34, 39, 42 and 43 have been received, but they remain unrepresented. Stop. And meanwhile, AD cards from respondent number 37, 38 and 40 are still awaited. Stop. The state respondent number 52 is represented by Ms. Caroline such and such, who is stated to be on leave, and same order, okay, and they prayed for 3 weeks time to file the affidavit. So list on 25/11, the interim order passed earlier shall continue till the next date.
Item 6.
My lord, here there are a total of 6 respondents. 1 to 5 is private respondent, my lord. 6 is the state. All are represented and served. Counter affidavit of 1 to 5 has already been received, my lord. We are yet to receive the counter affidavit of the state here, my lord.
Okay. Here as well, learned counsels and such, same order. Then you say that the respondents number 1 to 5 are represented by MS such and such, and who submits that the affidavit in opposition in respect of respondent number 1 to 5 has already been filed. So the state respondent number 6 is yet to file the counter affidavit and is represented by Ms. Caroline such and such, government advocate, and it is prayed that 3 weeks time may be given to the state respondent number 6 to file the affidavit in opposition. Stop. List on 25/11. The interim order passed earlier shall continue till the next one.
Item 7.
My lord, here also, my lord, there are only 2 respondents. One is the private respondent and the other is state. Both are represented. Private respondent's affidavit has come on board while we are awaiting an affidavit from the state, my lord.
Yes, counsel for petitioner such and such. Stop. So the respondent number 1 is represented by MS such and such, and she submits that the affidavit in opposition on behalf of the respondent number 1 has already been filed. Stop. In the present case, the state respondent number 2 is yet to file the affidavit in opposition. Stop. The state respondent number 2 is represented by Ms. Caroline such and such, same, and list on 25/11, the interim order.
Item 8.
My lord, here in total, my lord, there are 65 respondents, my lord. Out of 65, my lord, 64 are private respondents, 65 is state. My lord, as per last order, my lord, it shows that everyone has been served over here, my lord. In so much so that for respondent number 47 and 63, the AD card has been received back, which shows it has been served. Now, we have received the affidavit, my lord, over here. Respondent number 1 has filed an affidavit, and all the other private respondents are relying upon the same.
No, there are several respondents whose AD cards are still awaited.
My lord, as per order dated 7/10/25,
No, the office note 2810 indicates that respond 2, 6, 8, 9. Learned counsel, you are appearing for
For some of the respondents, my lord.
not 2, 6, 8, 9, 10.
No, my lord.
Yes, yes. I think you are appearing for 1, 3, 4, 5, 7 to 12,
Yes, 12 to 15,
Yes.
17 to 18, 20.
20, 22 to 24. Yes, yes.
Yes.
Okay.
And we have filed the affidavit. The land counsel for the petitioner has said that he will file a reply affidavit.
Yes, he is
But he
saying
has
that
not
he will
done
file a joint reply to
My
the.
lord, how can a joint reply be made? If the state government is filing affidavit, it will be a separate affidavit.
my lord, we'll file a separate reply
It's
to
it's
them.
up to them.
We'll
Let the
file.
government
By next date,
file.
we'll file it.
Yes,
The
let-
state respondents, we have nothing much to say, but if some time can be granted, we'll
yes,
file
yes, yes. In other cases, 3 weeks has been given. It will be listed on the same day. Learned counsel for the petitioners and such. In the present petition, all the respondents are represented by Mr. such and such. Give his name, except respondent number 2, 6, 8, 9, 10, 11, 16, 19, 21, 25, 26, 29, 32, 34, 36, 37, 38, 39, 43 and 44 whose AD cards are still awaited. Stop. The state respondent number 65 is also yet to file the affidavit. MS Linda L. Fambul, Learned Additional AG, appears for the state respondent number 65 and prays for 3 weeks' time to file the affidavit on behalf of the state respondents. So prayer is allowed, list on 2511, so and such. The interim order passed earlier shall continue till the next date.
Item 9.
My lord, as per previous order, it said that everyone has been served.
Except those. No, but
My lord,
the office
my lord,
note.
second last paragraph. So, my lord, an observation may be made in this order that still this service is awaited. So, if required, we will take fresh steps also. It might create a confusion, my lord, to subsequent or in one.
Order dated
7/10/25, my lord. Second last paragraph, my lord. As far as respondent number
47 and 63 are concerned, the AD card is received back. Okay, you just add one more line. In respect of respondent number 47, 48, 51, 47, 48, 51 and 63, the AD card has been received back as per the office note dated 28/10/2025. Stop. Yes, that will do.
my lord.
Item 9.
Here, respondent 1. Here for respondent 1.
One and I have filed my affidavit, madam.
Yes, learned counsel for the petitioner, Mr. Saris is present. So, respondent number 1 is represented by Shri such and such, and the affidavit has also been filed. Stop. Notice upon respondent number 2 to 5 is complete as per the office note dated 28/10/2025. Stop. The state respondent number 6 is yet to file the affidavit, and Learned Additional AG, Ms. Linda Fumbles, prays for 3 weeks' time to file the affidavit on behalf of the state respondent number 6. So, prayers allowed, list on 2511, interim order.
Item 10.
My lord,
Yes.
in this matter, my lord, in total, there are 37 respondents, my lord. 1 to 36 are private respondents, 37 is the state respondent. Now, my lord, state respondent has sought time, that is 37. Of the private respondent, my lord, service report on respondent number 29, 31, 32 and 33 is not returned till now. Other respondents, my lord, they have been served, but there is no representation for them. And respondent number 24 has already filed its counter affidavit, my lord.
You are for which respondent here?
Then respondent number 3, 7, 14, 19,
3, 7, 14,
19,
19,
21, 22.
21.
Yes, 21,
21,
22.
23,
Not 22, 22, my lord.
22, 21,
24.
22,
24,
24,
27, 30 and 34.
27, 30 and
34.
34. Learned counsel, Mr. Sir and such is present and submits that he is appearing for respondent number. Did you take down 3, 7, 14, 19? Yes. 21, 22, 24, 27, 32 and 34, and you have filed your affidavit and has already filed his affidavit. Stop. The office note dated 28/10/2025 indicates that the service on respondent number 9, 15, 16, 17, 18, 20, 23, 25, 28 and 35 is served. Stop. Notice sent to respondent number 26 has returned with a postal note within inverted commas not found,
26.
close inverted commas. State respondent number 37 is yet to file the affidavit. Respondent 26 is not found. You have to take fresh steps.
My lord,
Yes. Respondent number 37, the state respondent is yet to file the affidavit. MS Linda L. Fambawal, learned additional AG, is allowed another 3 weeks to file the counter affidavit. Stop. The petitioner shall take steps, fresh steps for notice on respondent number 26. Stop. List on 2511. In such, the interim order passed earlier shall continue to.
Item 11.
my lord, here also there are two respondents, my lord. One is the private respondent and the other is the state. Private respondent have filed their affidavit, my lord.
Okay. Learned counsel, such and such present. Stop. The learned counsel, Mr. Such and such, appears for respondent number 1.
1 and 2, my lord.
2.
1 and 2.
1 and 2.
1 and 2.
My lord, there are 3 in total. 2 private
Okay,
respondents, 1
1
state.
and 2, and submits that he has already filed his affidavit in opposition on behalf of respondent 1 and 2. Stop. The state respondent number 3 is represented by the learned additional AG, Ms. Linda such, who prays for 3 weeks' time to file the affidavit on behalf of the state respondent. Stop. Prayers allowed. List on 2511. The interim order. Yes.
Item 12.
May it please your lordship.
Yes.
My lord, the instant revision petition has been filed challenging the order dated 26/09/2023 passed by the Court of Civil Judge in execution case number 22 of 2020. This execution case has arisen from the order of the settlement of Lok Adalat, bearing Lok Adalat case number 36.
Acha, this is that one where it was
Yes.
translated,
Yes, my lord.
directed to be translated.
Yes.
Ah.
And the Lok Adalat award is on 26/02/2010. Brief facts, my lord. Brief facts is that the instant petitioner, he was initially he was a resident of Bero village, and during insurgencies, many villages were relocated and they were grouped into one single large town or place. And even the petitioner herein was relocated to Zemabok locality, where he still resides till today. And he,
No, the main issue here is regarding the
Yes.
interpretation of the Lok Adalat
Exactly, madam.
terms, isn't it?
Yes.
So it says efforts should be made to pay up the entire amount during the year 2010.
Yes.
So you're saying that it doesn't say that it has to be paid during 2010.
Yes, my lord. It only says that efforts
Yes,
should be made to pay up.
Are you disputing, learned counsel, are you disputing this translation? Because in the translation it says efforts should be made.
Yes, I accept that.
Yes.
But no effort has been made by the petitioner. So which is why we execute this award.
Can we remand it back to the executing court? We'll remand it back with some observations saying that the petitioner, the judgment debtor may be given time, maybe in installments or something like that, and that the executing court can monitor it.
My lord, one submission.
My lord, if your lordship could kindly come to page number 18, 18 of my petition, paragraph number 4.
Yes.
This is the impugned order. Even in this order, it has been reflected that the judgment debtor, who is the petitioner herein, had made an attempt twice in the month of June 2010 to pay up the whole amount, but that was not accepted by the respondent herein.
Why was it not accepted?
Because, my lord, according to the petitioner, the respondent number 1 herein had annexed to one judgment in title also number 24 of 1988. That is at page number 18 to it starts from page number 18, filed by the affidavit. filed in the filed by the respondent in his affidavit.
There were on both occasions that
So-
the lord refused to receive the money.
It is my the humble opinion of the petitioner herein is that the respondent herein knew that he is most likely to receive more compensation amount from the government. That is why he has not accepted my attempts to pay up the amount as per the local adalat award.
Where is that? Where is that?
It's the judgment entitled suit number 24 1988. It starts from page number 18 of the affidavit.
Of their affidavit,
Yes.
respondent affidavit.
Yes, and if your lordship could come to page number 27, paragraph 14. Paragraph 14, if I may read. Therefore, it is ordered and decreed that cancellation order issued by memo number so and so dated Aizol 30th January 1984 is illegal and is hereby set aside. In the result, the defendants are entitled to get rent from the defendants numbers so and so at the rate assessed by Deputy Commissioner Aizol District in conformity with the provisions of Urban Rent Control Act. If they fail to pay rent, the defendant should vacate from the land of the plaintiff and give vacant possession of the plaintiff. Now, my lord, this order, which has been set aside by the learned trial court, this order is at page number 14 of the same affidavit. Page number 14 of the same affidavit, and the English translated the true type copy is at page number 16. Page number 16 is the true typed copy. By this order, the land of the respondent herein was cancelled by the concerned department, which is at which your lordship will find at serial number 9 at page number 17. Serial number 9 at page 17.
Okay, this was cancelled.
Yes.
Paper cancelled and then.
This temporary pass number 664 of 1929 belonging to the respondent herein was cancelled by this order, and that this cancellation order was set aside and quashed by the learned trial court, directing that the petitioner therein should be paid rental compensation. So, my lord,
Okay, to be
it is,
compensated.
yes, it is the humble opinion of the
Fixed by the Deputy Commissioner.
it is the humble opinion and understanding of the petitioner herein that if the respondent did not accept my offer, then my attempt to comply with the order of the Lok Adalat award, he will get more money out of this.
The compensation.
Yes, my lord. Even though I have made an attempt 2 times in the month of June 2010, which has been reflected even in the execution order, my lord. And I have a judgment, my lord, saying that,
No, see, if
Yes.
we are to go for proper, full hearing,
my lord.
then I do not wish to take it up because we have no time now to write the judgment and pronounce it. But if you are willing, if both the parties are willing to remand it back to the executing court,
My
then order can be passed. Otherwise, I'll list it on Monday.
My lord, my lord.
My lord, on that
Yes.
one, I have to seek instruction from the respondent because in our version, they did not make any attempt to pay the
No, that
money.
is disputed by them.
Yes,
They're saying
that is
twice they have
disputed.
tried.
And while during the pendency of the execution case, we have tried to settle the matter. My lord, kindly see my affidavit in opposition para 8. I have mentioned here that we have offered them the respondent, the petitioner, did not accept the area of land, which is 34 into 12 square feet, which he occupied, and he want the larger portion of the land. And later on, we have again offered them 30 into 18 square feet in a consideration price of rupees 3 lakh, which he refused. So the petitioner herein doesn't want to settle the matter
No, but
from
after
our
all
opinion.
that, you went and appeared before the Lok Adalat, isn't it?
Yes.
My lord, that I object to what my learned friend has stated, because your lordship will see at the 5th line, my lord, from the 4th line of the terms of settlement that is translated by the registry of this court. If I may read, my lord.
Yes.
The moment rupees 50,000 is handed over, Mr. Dar Tuama will hand over the LSC to Mr. Laltan Puya. It does not say that he will hand over this much portion of the land to Mr. Laltan Puya. It says he will hand over the LSC, which means the whole of the LSC. So, my lord,
Yes, this is the Lok Adalat award,
Yes.
which has been signed by both the
yes,
parties.
exactly, my lord.
Yes. It doesn't say anything about the area. It
Exactly.
Yeah, it doesn't say about the area, but my lord, this Lok Adalat was
It simply
has
says
been
that
come
he will
up from
hand over
the
the LSC,
previous
which is the whole LSC.
settlement made by the parties, which I have annexed in Annexure 4.
No. This cannot be taken up today. You are listed on Monday, okay? List the matter for admission hearing on 3/11/2025. Because you're disputing everything.
Obliged, ma'am.
Item 13.
My lord, here there are two respondents, my lord. One is the private respondent and second is the state. My lord, private respondent, we have taken fresh steps on 16/10/2025 for service, and service report is yet awaited, my lord. And state is represented.
State also has not filed.
Yes,
And,
Lord.
yes. Learned Counsel, Mr. Sarinzaj, for the petitioner. Stop. The office note dated 28/10/2025 indicates that as directed by this court right order dated 10/10/2025, the petitioner has taken fresh steps for service of notice upon the respondent number 1 in the corrected address on 16/10/2025. Stop. However, service report has not returned till date. Stop. Accordingly, list on 25/11/2025 awaiting service report on the respondent number 1. So the government respondent number 2. Respondent number 2, represented by Ms. Linda L.M. Fambaul, additional AG, is also allowed to file the affidavit during affidavit in opposition on behalf of respondent 2 by 25/11. Interim order there. Interim order is there.
My lord, interim order.
Shall continue to the next.
Item 14.
My lord, here in total there are 4 respondents, my lord. 1, 2, 3 are private respondents and 4 is the state respondent, my lord. My lord, respondent number 1 has been served and service report on respondent number 2 and 3 is awaited, my lord.
Learned Counsel for the petitioner, Mr. N. Kera is present. Stop. The respondent number 1 has the notice on respondent number 1 has been served, but he is unrepresented. Stop. The AD cards from respondent number 2 and 3 are still awaited. Stop. The state respondent number 4 is also yet to file the counter affidavit. Stop. Accordingly, list on 25/11/2025 awaiting service report on respondent number 2 and 3, and also the counter affidavit of the state respondent number 4. So the interim order passed earlier shall continue till the next.
Items 15 to 18.
Highly obliged, my lord.
Yes.
My lord, item 15 to 18 and 20. these 5 petitions are bail cancellation petition filed by the complainant Mahindra and Mahindra Financial Services Limited for the grant of bail by the learned lower court. In item 15 and 16, the reply, the affidavit and responses awaited. Item 17 and 18 affidavit has been filed by the respondent.
17 and 18 are
Affidavit is filed.
affidavit filed.
We have received.
And item 15 and 16 not
15,
filed.
16 and 20 not filed.
15, 16.
But the case of item 15, the Zakir Hussain, he is the main accused. So we are pressing a early hearing in this case, my lord, because the Zakir is the main accused of this entire conspiracy.
If I may submit, Your Worship, in these matters, 2 FIRs were filed, and we have challenged the maintainability of the second FIR, and those petitions are still pending before this Honorable Court. And my humble submission is that the petitions challenging the maintainability of the second FIR may kindly be taken up before cancellation of bail, because if the second FIR is held to be not maintainable, then the question of cancellation of bail in the second FIR will not arise. Now it's like putting the cart before the horse. So now
And when are those cases listed?
those matters, in fact, they last came up in September.
Yes, they were directed to listed after 4 weeks, but
they have
no
not been
date is
listed.
showing.
So my humble submission, Your Worship, is that those matters may kindly be listed together with these matters.
Together with these.
And so that the second FIR maintainably challenging the maintainability of the second FIR, those petitions may kindly be taken up before cancellation of the bail application.
My lord, I have a suggestion in this regard, my lord. We have no hesitation in arguing those questioning matters, my lord. But they may not be tagged with the cancellation, my lord. Cancellation may be argued later on. But if my lord may tag all the matters.
Okay, then we'll keep this pending
till the
cancellation. Till the lodging of the second FIR maintainability is taken up, decided.
My lord, instead of keeping pending, my lord may give date on both the cases because counsels are same, so we have no difficulty if date is given.
Okay, those cases are?
Your Worship, those cases are criminal petition 18 of 2024,
yes.
19 of 2024, 7 of 25, 8 of 25,
and my lords,
11 of 25.
And my lords, 2 more, 26 of 25 and 1 of 25. All criminal petitions.
There is one more, I think.
Okay. 18, 19 of 24, then 7, 8, 11, 28 and 1 of 25.
Yes,
there is one more.
Then
my
the
lords,
other one?
26, not 28.
26 of 25?
Yes,
yes.
And 14 of 2025.
And 14 of 2025.
25.
Learned counsel,
They may be listed on 20th or 21st, my lord, if subject to the convenience High Court. Because matters are, I think there are some 7, 8 petitions. So if they can be bifurcated in 2 days, 20th and 21st, it will be easier for us to.
No, but in these other CRP 18, 19 and all, the date must be already fixed. It must be.
Date is not fixed, my lord, only they were directed to be listed after 4 weeks.
After 4 weeks. So when will 4 weeks expire?
It's already expired.
Already expired. Okay.
My suggestion, Your Worship, is let those matters be listed tomorrow. And we can fix a
No,
date.
no, not tomorrow.
Okay.
Tomorrow this court is sitting only till 12. Monday.
Monday, then we can list it for the 22nd. So for the 20.
Monday, my lord, I'm in some personal difficulty. I'm coming from outside.
Oh.
You can join from DC. It's only for fixing.
That is listed on 20th.
Yeah, but then the matters are
Not listed today. No? This we can fix. My lords.
No, we are discussing about listing these other CRPs. Yes.
Yeah.
This one will take it up again.
These matters may be listed after 4 weeks. Then. In the meantime, we can try to dispose those.
My lord, let those matters be listed on Monday, my lord. If my lord permit, I'll appear through VC and we fix those matters.
Yeah,
But
we'll have to have the registry to raise that. The court cannot pass an order because they are
That
not
will take it up with the registry.
Because it will come up in the usual
Yes.
course, no? After 4 weeks it will come
We'll
up.
take up that with the registry and we'll get it fixed on the 20th.
So you keep track and then these ones will fix it
After 4 weeks.
after 4
They may be
weeks.
fixed on
Yes.
27th, Malu, because we come from outside, so it may be kept on 27th
27 November.
November.
These matters.
Today's matters.
Okay, okay.
27 and 28, Malu.
Learned counsel for the petitioner, Mr. Such, your name, in item 15, 16, 17 and 20, okay? No, 15, 16, 17, 18 and 20. Stop. Also heard, learned counsel, just take all your names. Such for the respondents and the number of respondents, okay? Stop. It is submitted at the bar that a batch of criminal revision petitions have been filed challenging the maintainability of the second FIR filed in the connected case, and accordingly it is prayed that these matters may be listed after the disposal of the said criminal petitions, which are to be, okay, just say after disposal of the criminal petitions, stop. Accordingly list on 20, accordingly list these matters on 27/11/2025. Yes.
Yeah, in the meantime,
My lords, in item 18, item 20, my lords, affidavits may be exchanged. 15 also. I believe
Okay.
15 also.
It is also submitted that in item 15 and 20, you just write the WPC number later, okay? Item 15 and 20, the affidavit on behalf of the respondents is yet to be filed.
And 16 also,
Is
Madam.
yet to be filed.
15, 16 and 20.
15, 16, 20.
20.
15, 16 and 20, affidavit is yet to be filed on behalf of the respondents. Accordingly, the pleadings may be, the affidavits may be filed and the pleadings may be exchanged before the next date.
Vaishapa, just in the first sentence, your Lordship had said criminal revision, I think. It's a criminal
Oh,
petition.
sorry, criminal petitions, not
Petition.
revision, criminal
Not revision,
petitions. Yes.
Obliged.
Challenging the maintainability. no?
Obliged.
Yes.
Item 19.
Yes, I think my cost list is there. This is the reading cost list, no? I think it got tagged along with the file.
My lord,
Yes.
this is petition for quashing of criminal complaint
Hmm.
filed to, now it's pending in before magistrate first class. So on my lord, solely my grounds is for the transaction is loan is, this is civil nature, and Chief Justice, CJM already concluded from the investigation that it was a civil case, and there's nothing short of this. That is my main grounds in these matters. So my lord, allow me to start from the FIR. It is there, start from 57.
Page. Acha, who's appearing for the respondent?
I'm appearing for the respondent.
And state?
My lord, there's no state. Actually, this is a private complaint.
Oh, private complaint. Okay, okay. Page?
FIR start from 57, Your Lordship. And everything is clear from their FIR.
Yes.
Allow me to read the Lordship, please.
Yes.
Mercy Pet Care deals in animal foods and medicine and was previously owned by Lal Nunpui, proprietor, wife of Dr. Lalina Makiangte. I, Lal Muanomi, used to work at Lal Nunpui. Lal Nunpui is now the petitioner here, shop at Mercy Pet Care. By the end of 2022, Lal Nunpui and her family decided to work as missionary and prepare to leave for Delhi. They have decided to sell some portions of Mercy Pet Care wholesale distribution as they are in no capacity to take care for the said business. Lal Nunpui said that there are many interested buyers for Mercy Pet Care in as much as 3 crore offer existed from person interested. And since I, Lal Nunpui, has been working with her and that since we are related, She told me that she wants me the most to take care of the course of business. However, despite being eager to take care of the business, I have no money required for purchase of the said business, and that I am reluctant to avail loan for fear of fluctuation in repayment. And I told them to Lal Nun Pui, who in turn said that she can avail loan for her, and as per her calculation, the duration for repayment would be around 5 years. Then Lal Nun Pui took me to several banks to inquire for loans. Punjab National Bank PNB Chanmari branch Aizawl manager Pu James advised us to avail the same. A sum of rupees 1.5 crore rupees was attempted to be availed through Mercy Pet Care distribution, being mutated to my name. However, PNB Imphal told me that New Farm cannot avail such huge amount since I could not avail the loan in my name. After a thorough discussion with Lal Nun Pui and PNB manager, the former has agreed out of her own will to apply the cash credit loan in the name of Mercy Pet Care trade license amounting to 1.2 CR, and the said sum was disbursed to me very shortly. As the bank manager said that the current account in the name of Mercy Pet Care at SBI Ramlun branch has to be closed by Lal Nun Pui, he therefore told the need to execute a power of attorney to me, Lal Muan Omi, to regulate the transaction in the account of Lal Nun Pui at PNB Chanmari. The loans having been availed in the names of Mercy Pet Care, Lal Nun Pui, we felt that executing an agreement in the form of sale deed cum agreement became necessary, which we did so on 26/6/2023. As per the agreement, all the funds totaling a sum of rupees 1 CR availed from PNB to, though availed in the name of Lal Nun Pui, shall solely for Lal Muan Omi, and Lal Nun Pui only bears the names on the loan. As required by the banks, a security mortgage was made by mortgaging the LSE as at L14/30 of 1992 belonging to my father, Laltan Siama, who consented to the same. Further, as per the prior agreement, Lal Nun Pui took the sum of 91,88,730 for purchase of Mercy Pet Care wholesale distribution, and I, Lal Muan Omi, is in charge of the loan payment and anything related to such. Also, the remaining fund from the sum of 91,88,730 paid to Lal Nun Pui has been utilized for startup of business. Loans were repaid regularly from January 2023, despite some challenges. The CC loan has been repaid regularly up till January 2024. Having conducted the business smoothly, it has become necessary to renew trade license of Mercy Pet Care in the name of Lal Nun Pui, and the said and has agreed to renew the trade license but makes several excuses and did not renew the same after being handed the physical trade license and had failed to submit renew license to Punjab National Bank, due to which our loan account has been freezed. Lal Nun Pui made us unable to repay the loan amount after acquiring the sum she wished, and she has not submitted the power of attorney required by the bank and renewed the trade license to the bank. From a further inquiry, I find the distribution license are not to be sold, and Lal Nun Pui had taken 91,88,730 from the loan amount, and she pays no heed even we met the worst scenario. Thus, she has deceived us right from the initial. We have had family meeting on several occasions regarding these matters, as it involves large amount of money, and that we are on the verge of losing my father's LSC, which we submitted as collateral security. We discussed the need for execution of power attorney, renewal of Mercy Pet Care trade license for submission to the bank. Lal Nun Pui also seems to pay heed to our grievance. However, till date, she executed no power of attorney nor renewed the Mercy Pet Care trade license to the bank. Due to this action, loan availed to PNB Chanmari branch has been declared as NPA, will soon turn into a default, and we are likely to lose the LSE mortgage by my father. Due to the reason mentioned, we feel that Lal Nun Pui has breached the agreement between us, and I request you to book her with provisions of criminal breach of trust, section 406 IPC, also with provisions of section 420. Due to the fact that she has made us unable to repay the loan, due to the action committed by Lal Nun Pui, we are on the verge of losing large sum of money that our family have been troubled by sleepless nights. Due to the reason aforesaid, I request you to kindly register this FIR against Lal Nun Puyi and take necessary action in this regard, and filed by Lal Muanomi. This is the respondent here. They have enclosed sale deed agreement and loan statement also. Your Lordship, here, very interestingly, they filed this FIR, and this is the remark. The police investigated. If you kindly see just above page number 57, because 56 is the Mizo version, and handwritten one is the remark by the police at 56.
At the bottom.
Yes, at the bottom.
Oh, this is the remark by the IO, OC.
OC. FIR was filed on 27. It was received on 27 March, and this was written on the next day on 28 March. Can you read it?
Yes,
It is
please read.
handwritten. And also, Your Lordship, we type it also.
Type copy also.
The type
yes.
copy is at page number 59.
Yes.
It is to be noted that Guwahati High Court recently quashed 2 cases of such nature registered at this police station, stating that such breach of contract need to be proceeded by initiating civil suit, and police has no justification to register a case. FIR clearly speaks of its being civil in nature, hence complainant is advised a suit against defaulting agency accused person. I also have these 2 cases filed in the police station. They investigated and they approached this court under 482, and it was quashed, and I have the 2 copies also. I have put in my grounds also here.
So that means the police did not investigate.
They investigated, it was filed on 27, and seeing the FIR itself, they say this is civil in nature.
Civil in nature.
Then they refer to go to civil court. And Lordship, and then after this, she filed that impugn complaint, complaint number 1, 2024.
Yes.
So everything is one and the same.
Then after that, the court took cognizance.
The court, actually, this is quite, let me say, a peculiar case. So the court did not take cognizance, but the court attempted somehow to freeze the trade license and also try, not actually what I say that it was proceeded, it's a kind of civil nature without taking any cognizance, and they keep calling, because we stay in Delhi. We have to come all the way from Delhi there, because I have very serious eye problem. I have to go to Cuba. I need one support all the times. Despite that, she had to appear to the court, but the cognizance was taken at all. But Your Lordship, one thing is that I would like to take you to page number 72.
Yes.
So, my Lord, that the petitioner herein filed this transfer application under 408 CRPC. So, my Lord, the main grounds I would like to inform the court is that para 5 is important, the grounds. It at page number 75.
Yes.
The petitioner found that the trial magistrate is a close neighbor with the complainant, respondent. As such, petitioner received a reliable information that the complainant, respondent, and the trial magistrate had a conversation in regards to pending litigation before this instant complaint has been filed. The trial magistrate provides her positive words in her favor. It is also pertinent to mention that the trial magistrate, through telephone, informed relatives of the complainant respondent and telling that the case was in favor of the complainant under her administration and they have nothing to worry about it, so that petitioner is being afraid of that purpose of law. Justice cannot be achieved from the court in which this instant case is pending. The trial magistrate had conducted herself in such a manner that no fair or impartial inquiry trial can be expected from her, and therefore transfer of the case is necessary for the interest of justice. It is also pertinent to mention that from the proceeding of the criminal complaint till date, it can be drawn out that apprehended that the trial magistrate, where this instant criminal case is pending, is having personal interest, so that justice could not be achieved due to some external influences which hampered the fairness of the court. My Lord,
After that, it was transferred.
my Lord, it was not transferred. Actually, we came to know from the police that we had received order from the court to investigate these matters again. You kindly see the order 83. Page number 83. So, my Lord, actually this order, we are not there, copies of this application was not given to us. We came to know from the police, and this order, they filed application for reinvestigation before the trial judge, and the trial judge, without hearing us, directed the police to investigate again. So if you kindly see that, page number 85. Para 6. This court, by invoking section 156(3) read with 190 CRPC, hereby directs the police in charge, Aizawl Police Station, Aizawl, to register FIR dated 73(3) filed by the applicant and to proceed with the investigation for the proper adjudication of the case and submit the report on or before the next returnable date, and fix such and such 13/8/2024 submissions of the report. What I would like to stress here is that this, though our name is reflected here, counsels for the accused, there is nothing that we received copies of their application, and also this order itself. We came to know only from the police. And my Lord, interestingly, if you kindly see the investigation, after this order, the next page, 86, is again, this is final report.
Final report.
It's short, elaborate, and allow me to read, Your Lordship, please.
No, finally the charge sheet was submitted.
Charge sheet was submitted,
Saying
it was
that-
accepted. My Lord, at least the conclusion part, can I read?
Okay.
The conclusion part is this one. From the last two
Page
para,
87.
87.
Yes. From the above.
From the above fact and circumstances, Lalmuan Omi believed that Lalmuan Omi is the respondent, that appellant Lal Nun Pui is the petitioner here, had breached their contract between them. Therefore, she submitted first information report to Aizawl Police Station on 28/3/2024. After carefully studying the complaint, it was learned that the case is civil in nature, and thus the complainant was advised to go to the court for initiating civil suit. Later, the court of Lianmoi Haunar, Judicial Magistrate First Class Aizawl, directs the police in charge to register the case vide number such and such, and therefore the case has been registered at Aizawl Police Station under such and such 402/422. During investigation of the case, it has been asserted that the provisions of section 406 and 420 IPC is not applicable in the present case because the trade license was handed to Lal Nun Pui from the bank for renewal, and after renewal of the license, he has not given it back to the bank. This had caused problem to the complainant in repayment of the loan to the bank, but there was no dishonest misappropriation, converting, use, or disposing of the property. As such, there is no need to proceed further investigation of the case. Therefore, I beg to submit the final report without charge sheet since the case is civil in nature. My Lord, till now they have not challenged this one.
Okay, and then the court
Then
has
this was
also
88, if you kindly see 88.
magistrate has accepted
Here
this.
received the final report number 152/24 dated 28 submitted by the case IO.
The final report is
Since
accepted.
the case is civil in nature, final report is accepted. Even this order was never challenged till now. So I have two limbs of submission in this respect. The transaction itself is civil in nature, one, and also despite filing the complaint, the magistrate directed the OC to investigate the case, and the
It's not transferable. That was not being told to me. First, in that ground alone itself, there's a cheating, Your Lordship, and thereafter, if I may take you to the page, 59 of the FIR. Due to the reason, due to the reason mentioned, we feel that Lalun Pui has breach of agreement between us, and I request you to book her with the provision of breach of trust 406, along with provision of section so and so 420 IPC cheating. This criminal complaint is basically on cheating, on the ground of cheating and breach of trust. This is, and if you see the bottom note that the police have wrote, it is written as, it is to be noted that Gauhati High Court recently quashed 2 cases of such nature registered in the PS, stating that such breach of contract, if I may kindly, breach of contract need to be proceeded by initiating civil suit. We are not talking about the breach of contract. Now we are talking about the breach of trust. We are not complaining breach of contract or breach of agreement. We are talking about the breach of trust. 406 and 420 cheating. First of all, as we have mentioned in the FIR, the petitioner was supposed to sell the pharmaceutical license first of all in the first place. I was cheated already. As I was.
Let me just
explain.
There is nothing we sold the pharmaceutical license.
No.
You'll have a turn.
That's wrong submission.
This is my FIR. Whatever the facts of the case comes from the FIR.
No,
whatever
it may be,
yes,
in connection with this FIR, the final report is filed.
Yeah, final report was made.
Isn't
final
it?
report was made,
Final
and it doesn't
report-
mean that if I may take you to page 88. It's just accepted. Doesn't mean that the court has it's just mean that the court has received the report. And if I may take you to the
No,
court,
it's like this. Final report and charge sheet. These are two different things. So when the IO finds a prima facie case, then charge sheet is filed. So, and when there is no prima facie case, then a final report is filed. So as per CRPC, when the final report is filed, unless the court directs for a fresh investigation, the case will be closed. That's it.
Yes, Your
The
Lordship,
court will accept the final report and close the case.
the court has received the final report, but then immediately after receiving the final report, they have appealed this criminal complaint.
No, unless the final report is challenged, unless this final report is challenged before appropriate forum, or you pray for a fresh investigation, there is nothing for the trial court to proceed now.
And Your Lordship, if I may take you to the this Honorable Court Order 27/5/2025, passed by the learned Justice Michael Jotan Kumar, and even the police has wrote a note in the below that was passed by Justice Michael, and even the one who passed the order itself, he had an observation. The last two para. The rest
Where?
yes,
Where?
yes. Prima facie.
Page.
No, in the
No, it is there in
court's
the order sheet, you know.
Order sheet.
Oh, order sheet.
27/5/2025. before I go to that, I would like to make a mention that the court, JMFC, the magistrate has taken cognizance. And my last friend was saying that cognizance was not taken. It was taken.
Yes,
The last para,
27.5.
The last para.
Last para.
Prima facie, this court finds that the action of the petitioner could amount to cheating. However, as it has been stated that the trade license is in the possession of the concerned JMFC, ISOL registry is directed to call for the trade license along with its LCR. And now, here the court has clearly observed that there is a primacy against the petitioner.
No, fine.
Yes.
There may be, but final report. What does
Yes,
this court
and
do
let me
now?
just
Final
explain.
report.
And after that, when the trade license, when the LCR was called by this honorable court, my learned friend, a petitioner, have, without our knowledge and consent, they feel bad about it. They submit the trade license to the bank. That the court has not known about it. It has not become the knowledge of the court. So that means they have cheated something and they feel bad. The action of the petitioner has already proved that they were cheated and they have breach of trust already. This is not a breach of contract or breach of agreement. This is a breach of trust.
Okay, fine.
It's a privacy.
Assuming but not admitting that 420 is made out prima facie, but in view of the final report, now what can this court do? That is what I'm asking. Because when there's a final report by the IO saying that no prima facie case is made out, then all that the court has to do is accept it and close the case, or direct for a fresh investigation. The magistrate has to direct for a fresh investigation. Magistrate cannot take cognizance and proceed in view of this final report. See, it has been ascertained that the provision of section 406 and 420 IPC is not applicable in the present case. So beyond this, what can the court do?
Mr. Lordship, after the FIR final report was received, and nothing was done by this court. There was no proceed in this procedure. The criminal complaint was not proceeded by the court. It was the last order, I believe, this one. So.
No, that's why. Now, see, this final report is already there in respect of the FIR, isn't it? This final report. So, and the court, the magistrate has accepted the final report. So, after this, the final report acceptance is 26/9/2024. After this, how can the court proceed to take cognizance? Court cannot, the trial court cannot. You got my point?
Yes, a lot.
Because the final report says there is no case. Okay. So on the basis of the final report, how can the trial court say no, there is a case? Unless the trial court gives a direction for a fresh investigation, saying that even if the FR says so and so, like, there may be something, so go for a fresh investigation. Court has the power, trial court has the power for fresh investigation under CRPC. But on the basis of this final report, nothing can be done.
Yes.
So
for
the
taking
court,
a fresh investigation, that is to be taken up by the magistrate. But
on your prayer, you can
yes,
also pray. Yes.
But nothing has been. The court has not been functioned. She was on leave, and after that they made an appeal, and there is another civil case pending. So
in regard to the same,
and besides that, as he was submitted, he was
then you pursue the civil case.
She was in Delhi, so the court keep on adjourning the cases.
No. I will quash everything. I will quash the proceedings in view of this.
I would like to assist the court by filing a Supreme Court judgment, recent judgment. Then Naresh Kumar. Then here at para 6. If you kindly see para 6.
No, this court will not go into whether it's civil or criminal. We will just go by the FR, the final report.
That's also my submission, my prayer. My lord, two submission I would like to just rebut. This one is
Because
that
there may be something, okay? Because initially the trade license,
My lord,
the pharmacy license cannot be transferred, but that was not,
That was already
that was,
My
not,
lord, my
that
lord,
was
that-
suppressed.
right now, if they can show that we sold the pharmacy license.
No, we will not go into that aspect.
No, my lord, at least they have to prove where is the sale deed? Where is the sale deed for selling pharmacy? They make submission before Justice Michael also that day. Even Justice
cannot
Michael
argue
wanted,
at this stage.
no, my lord, Justice Michael wanted to see. He called the case record. It is there, the trade license. There is nothing that we sold the trade license. Nothing at all. That is one point.
Pharmacy license or
Not
trade
at all,
license?
not at all.
No,
We
no.
have not sold any license. At least if we sold the license, they can prove it, they can file the documents. We have not sold.
We will not go into that aspect.
And one another point is that, Your Lordship, they admitted their guilt and they renewed their license and they submitted to the bank. The thing is that, my Lord, we have not
Actually,
sold.
they have
Let me just-
admitted, they have
no, no, my
admitted
Lord.
that they have
My
sold
Lord.
the trade license.
No,
they
no,
sold
my Lord,
the
let me just
pharmaceutical
let me
license.
just explain.
Now
It is
they
still
are
it is still in our name. It is still in our name because Aizawl Municipal Council, it was expired and there is a penalty of, I forgot, it is might be 100 rupees every day. After expiry, I have the liability
Fine.
to fine. Then it keeps going
And
on.
also, Your Lordship,
No,
if I
no,
may-
let me just complete.
The lordship, this court has asked for the LCR and the trade license was there. Without the knowledge of the court,
No,
this
no,
court,
we can-
they have
No, my Lord,
they
with
have
Xerox copy.
they have renewed the trade license.
No, no, my Lord.
Submitted in the bank.
We
without the
can
knowledge of the
renew
court, without our knowledge.
with photocopy, Xerox copy. With that Xerox copy,
I know
we
you can do
renew.
it, but the court was asking for the LCR.
And my Lord,
When
the
there was
main-
a pending case, you're not supposed to do that.
No, no, my Lord, we can do that. There is no stay order at all.
Okay, we will quash the
My
proceedings.
Lord, that
And
criminal
if
141 of 2024, that I mistake, I just submitted 1 of 2024, that criminal case.
which one?
141.
Which one? And let us see your prayer also.
That's 31. And 32.
Page?
31 and 32 and 33. Your Lordship, in fact, you are the one who give us interim order also relief at the very motion stage.
If you are not satisfied with the final report, you pray before the magistrate again for a fresh investigation.
Yes, Your Lordship.
Yes,
If you-
and
if I
pursue
may
the
please,
civil case.
Make a submission that make a observation that
Yes, yes, we will say that if the complainant is not satisfied with the final report, a prayer can be made before the magistrate for a fresh
My Lord,
investigation.
actually, one submission, my Lord,
Yes.
because 482 power is very vast. That transfer petition is not yet decided since they.
It's already decided.
No, no, my Lord, even you can transfer to another musician.
No,
because
what
that-
remains now? I'm quashing the entire proceeding.
And because the transfer application, the allegation is very serious. There was no proof, and they are saying that the JMFC court is calling the other guy and saying this.
And
That
those-
allegation is very serious.
those-
And then they did not want to proceed before the district judge, and they withdraw it.
No.
That's the issue.
Such allegations cannot be made like that
Yeah.
unless
If you
it's,
don't
it's
have a proof,
supported
you're not supposed to do that.
supported by proof and
No,
affidavit.
No, that's
That's a
fine.
serious allegation.
Against
At
a court.
At the time, as per provisions of law, there is a provision, they filed in they made application.
But the statement.
No,
is-
but what I
statement-
mean is the allegation against the court.
Yes.
Allegations against the court.
Yeah,
There are
that's
many
all, my Lord.
regulations.
Yeah, but
Just
since
bland
it is there in the
allegations
report,
cannot be made.
though I was not appearing in the trial court, then I have to enclose it, Lordship.
Okay, heard learned counsel for the petitioner, Sri such and such. Also heard learned counsel for the respondent. This is item 19, yes. Stop. Para. In this petition under section 528 of the BNSS, the petitioner is praying for, you can sit, the petitioner is praying for quashing of the criminal complaint number 151 of 2024, as well as the FIR, dated 27/3, no. Okay. Yes. Where is the date? 27/3/2024. Stop. No, comma, filed by the respondent against the petitioner under section 406 and 420 of IPC, which is pending before the Judicial Magistrate First Class dash number 5, Roman 5, okay, comma, Aizawl District, comma, Mizoram. Stop. Comma, para. The ground taken by the petitioner for quashing of the criminal complaint is that the allegation against the petitioner in the FIR is civil in nature and that the OC of the Aizawl police station had also refused to register an FIR against the present petitioner, with a noting at the body on the body of the FIR itself that the respondent was advised to approach a civil court.
Yeah, please, Your Lordship, if I make a small
Yes.
point, I'm just, according to my understanding,
Yes.
I'm looking at the prayer of the petitioner, and there is no prayer for quashing of FIR. It's only for the prayer for quashing the criminal complaint.
Yes, you have not prayed for quashing the FIR. Okay, don't say FIR, the criminal complaint. But the criminal complaint arose out of this FIR.
No, actually.
Then why you didn't challenge the FIR?
It was not arose because FIR was filed, case was not registered. Nothing was proceeded.
But the FIR was
Then,
not challenged.
then only
Then later,
they filed direct to magistrate.
so magistrate directed for investigation.
yes.
Okay.
But the FIR was not challenged.
So that has to be challenged actually. Refused to register the FIR against the present petitioner with the noting and the body of the FIR itself that the respondent was advised to approach the civil court, and thereafter the FIR was not registered. Stop. Para. Upon refusal of registering the FIR, comma, the respondent approached the trial court under section 190 CRPC and submitted a criminal misapplication, i.e. criminal misapplication number 236/2024 under section 156 clause 3 CRPC, read with section 190 CRPC. Stop. The trial magistrate thereafter, by an order dated 4/6/2024, directed the OC Aizawl PS to register a case against the petitioner and to investigate the matter. Stop. After thorough investigation, the investigating agency submitted the final report on 28/8/2024, and in the final report it was reflected that the provision of section 406 and 420 IPC is not applicable in the present case, and there was no dishonest misappropriation, converting, use or disposing of the property. Stop. As such, there is no need to proceed with further investigation of the case. Stop. The said final report was accepted by the magistrate on 26/9/2024.
Actually, my lord, the one who accepted is CJM.
Oh, CGM. It's okay. I said magistrate. The learned magistrate accepted the said final report on by an order dated 26/9/2024. Stop. The petitioner therefore submits that the trial court cannot proceed further with the criminal complaint, inasmuch as the final report has already been accepted, and he has accordingly prayed for quashing and setting aside of the criminal complaint number 151 of 2024, pending before the Judicial Magistrate First Class. Now also it's before JMFC. It's pending
Yes,
before JMFC. Before.
But I'm not sure if this final report is with JMFC.
No, I'm sure it is not before. It is before CJM.
Yes. That means JMFC who deal with this trial court has not received.
Doesn't know about it.
Doesn't know about this. Yes, Your Lordship.
Okay. Before the JMFC First Class dash Roman 5, Aizawl, Mizoram. Stop. Para. Learned counsel for the respondent, on the other hand, has submitted that the FIR lodged by him dated 27/3/2024 has clearly revealed a prima facie case of criminal breach of trust and cheating under section 406 IPC and section 420 IPC, inasmuch as the respondent and as much as the petitioner never revealed to the respondent that the name on the trade license cannot be transferred.
The pharmaceutical license.
The pharmaceutical license cannot be transferred to another person. Stop. Therefore, from the very inception of the contract/agreement between the parties, the ingredient of section 420 IPC was present. Stop. However, as the OC of the Aizawl PS refused to register the FIR, the petitioner, the respondent, had to file the criminal misapplication number 236/2024 before the learned magistrate, and upon which the magistrate
type copy 67.
No, when it is a complaint case, of course the accused can be summoned. To give the statement.
My lord, examination of witnesses has to be done, and under CRPC 200, if you see everything, very drastic order was passed, very short.
Okay, so that means two parallel proceedings are going on. One is a criminal complaint, it's taken up as a complaint case, and one where the CJM has already accepted final report.
That CJM accepted that final report is continuations of this order passed by the JMFC.
They have mistaken, according to my understanding, the police
No, my lord.
department has mistakenly submitted to the CJM.
Mistakenly
No,
submitted.
normally they submitted this copy to JMFC. The process we have is that whenever FIR is filed in the court, it is the CJM who received this.
No, but if the CJM has already endorsed the case to the JMFC, JMFC
It should be
It should
filed
be
before
Lord,
the
if-
JMFC.
my lord, allow me just to make one more point, because if we go by, I have some citation passed by this honorable court, so that it will be clear, because this is also our point. Because the manner how the trial court is conducted, just I would like to submit that from the this 92 I have enclosed in my petition also, page number 92. And that relevant is 98. Para 6. Because the JMFC did not produce whether that the complaint falls under the category of criminal offense. Because 482 is very vast. May not allow me to read para 6. Para 6 in case
No,
of
this here again you're going on civil nature.
no, this is
Civil nature.
482 power. 482 power is very important from that reading of the FIR itself and the complaint itself.
No, no, no.
Just only two
But-
paragraphs.
He is not challenging the FIR.
No, not
But
the complaint I say.
I'm not going into this civil nature issue.
Yes.
Okay, I'm not going into it. So this judgment you're referring to is relating to the civil nature. Okay, the last line. That JMFC. The learned JMFC thereafter directed the OC Aizawl PS to register a case against the petitioner and to investigate the matter by the order dated 4/6/2024. Stop. Accordingly, the case was registered and investigated. Stop. And as there is a prima facie case of section 420 and 406 IPC, the learned JMFC has rightly taken cognizance, and the trial and the proceedings had started, and the same is pending before the trial court. Stop. Learned counsel therefore submits that the petitioner has not been able to make out a case for quashing of the criminal complaint and the proceedings thereof, and therefore the present petition may be dismissed. Stop. Para. The court has considered the submissions of the learned counsels for the parties and also perused the pleadings and the records available before the court. Stop. It is seen that when the FIR dated 27/3/2024 was initially lodged before the Aizawl PS, the OC of Aizawl PS refused to register the same on the ground that the complaint was of civil nature. Stop. Accordingly, the respondent had to file the criminal complaint number 151 of 2024 before the learned judicial magistrate first class 5 Aizawl District, Aizawl. Stop. Praying for taking up necessary legal action for the criminal offence under section 406/420 IPC against the present petitioner. Stop. The case was duly registered as criminal complaint number 151 of 2024, and summons were issued to the accused person / petitioner. Where is the order? Have you annexed where the police was directed to investigate?
Yes, my lord. It's 83.
Page 83. By a criminal misapplication number 236/2024 in criminal complaint 151/2024, the respondent filed an application praying for a direction to the OC of the Aizawl PS to register the FIR dated 27/3/2024 submitted by the complainant / respondent. Stop. The learned trial court thereafter directed the OC Aizawl PS to register the FIR dated 27/3/2024 and to proceed with the investigation and submit the report. Stop. In pursuance of the said direction, the FIR was registered and the final report was submitted, by the IO of the case, being final report dated
My lord, at 86, and final report dated 28/2024. Page number 87.
29, I think. 28/2024. Stop. In Aizawl PS case number 245/2024. Stop. In the final report, it is stated that, and then you just reproduce this, okay? Page 87, last paragraph. From during investigation, ... till as such, there is no need to proceed further investigation of the case. Stop. Subsequently, the said final report was placed before the learned CGM,
Yes.
CGM Aizawl, and the court accepted the final report by an order dated 26/9/2024. Stop. It appears on the records that the learned JMFC-5 Aizawl District, Mizoram was unaware of the order dated 26/9/2024 passed by the learned CGM, by which the final report in Aizawl PS case number 245/24 has been accepted as it has been stated by the counsel for the parties that the criminal complaint is still proceeding. Stop. Para. This court is of the view that when the final report has been submitted by the investigating agency stating that a prima facie case has not been made out and that there is no need to proceed with a further investigation of the case, and when the final report is already accepted by the court, comma, there is no provision for proceeding further with the case. Stop. Therefore, the criminal complaint number 151/2024 pending before the Judicial Magistrate First Class Aizawl District, Mizoram, is hereby quashed and set aside. Yes.
That for investigation of the
No,
FIR
there
is
is no prayer at all.
in connection with civil miscellaneous criminal miscellaneous application 236 of 24. So the CGM should I believe that CGM should proceed, pass over this final report to the JMFC, and the JMFC should dispose of with the criminal miscellaneous application 236.
There is no such law at all.
Because investigation was done on the basis of criminal miscellaneous application.
Okay.
It is pending.
We'll do that. You delete that question part. Last para. That it is seen that the JMFC could not have proceeded with the such and such, and then stop. Next para. Accordingly, it is directed that the learned CGM Aizawl Mizoram shall endorse the copy of the final report dated 28/2024 in Aizawl PS case number 245/2024 to the Court of the Judicial Magistrate -5 Aizawl District, Aizawl, who shall then pass necessary orders closing the case in view of the final report. Stop. Para. The complainant/respondent is at liberty to take steps for re-investigation of the case.
Well, look, that observation, because the law, if there is the law, because there is
no, there is provision actually. You can approach any time.
They can avail it if the law permits. Then that part is unnecessary.
I may take necessary steps to close the case. Stop. With the above directions, the criminal petition stands disposed.
Well, then.
Yes.
Actually, that you have not decided yet whether the case is civil in nature or not. Just outside decision.
No. I told you that I will not decide on that.
That's why you have not decided, but
because
liberty can be raised afterwards also.
You can always raise.
Yeah,
because under 482, the court's power is vast. It doesn't mean that only because it is civil it will be quashed.
Yes.
If there is some illegality or impropriety in the proceedings,
that liberty,
that is always there for you. That is always open.
At least you make observation on YouTube. I can do that also.
That is always open to you. Yes.
So they must say that that it was already.
It is open to him also to apply for re-investigation. It is open to you also.
Since you kept quiet, then
the court will not say anything on that. Yes.